matter of Bokqui versus the Secretary of State for the Home Department.
My lords, my lady, good morning. I appear on behalf of the appellant with my learned friend Mr. Broachwala, and Mr. Tubbery appears on behalf of the Secretary of State.
Thank you.
Can I just check that the court has the bundles that we expect the court to have, and we have the bundles that the court expects us to have?
Yes, of course.
There is the core bundle that was prepared by the court.
Yes.
And there is a supplementary bundle of documents, which is a short bundle of 37 pages.
Yep.
There is an authorities bundle which runs to 292 pages, and there is a supplementary bundle of authorities that runs to 191 pages.
Yeah.
I'm grateful.
Thank you very much, and thank you both for cooperating and sorting that out.
My lords, my lady, this appeal concerns a point of statutory construction regarding the meaning of lawfully resident in section 117C4A of the 2002 Act. The upper tribunal held that residence pursuant to leave obtained by deception is not lawful residence for the purposes of that section. The appellant submits that that construction is wrong. Permission has been granted on two grounds. The first ground relates to whether residence for which permission had been granted by the Secretary of State, so that leave to remain had been granted, should count as lawful residence for the purposes of section 117C4A. The second ground relates to the period during which the appellant was on temporary admission, and at the end of which he was granted exceptional leave to remain, and whether that counts as lawful residence. The appellant's case is based on four propositions broadly. Firstly, under the statutory scheme of the Immigration Act as a whole, and as my lords and my lady will know, there are many of them, leave granted by the Secretary of State remains legally effective and valid unless and until it is revoked. Removal powers only arise once leave has come to an end. Revocation, like deprivation, operates prospectively, and therefore residence pursuant to leave that has been granted must be lawful residence for the purposes of the statutory scheme as a whole of section 117C4A within that statutory framework. That is the way that the system of immigration control is set up, and to hold otherwise would be inconsistent with the overall statutory scheme. Secondly, the scheme already provides for mechanisms to address deception. So there are mechanisms for revocation of leave, that is revocation of leave short of ILR. Those mechanisms are within the immigration rules. There is section 76 of the 2002 Act, which provides for revocation of ILR. There are deportation powers where there has been criminal offending, and that would include deception. And of course, the 1971 Act creates criminal offences relating to deception and other categories of immigration offence. But Parliament did not provide that such leave retrospectively becomes unlawful. The appellant's submission is that the tribunal's approach inserts a rule to that effect into section 117C4A, which is contrary to the plain language of the section and contrary to the scheme overall. Third, if one construes section 117C4A in the way that the upper tribunal did, this results in inconsistency within the statutory scheme and the overall system of immigration control. The rationale for the upper tribunal's interpretation is that a person that has used deception should not benefit from it. However, the effect would be that innocent parties to that deception and in other circumstances would also be penalised. It would also call into question the status of residence where other criminal offences have been committed, such as overstaying or working in breach of conditions. And finally, although this relates to a different, doesn't relate to revocation of ILR and relates to deprivation of British citizenship, the decision of the Supreme Court in Hisage which is in the supplementary bundle of authorities, confirms that status obtained through deception, in that context, British citizenship, is not legally void and a nullity from the outset. It remains effective until statutory powers are exercised to take away the status. The appellant submits that the same logic must apply here. If it does not, then again there is a clear inconsistency
Is that quite
within
right?
the statutory scheme.
Didn't the Supreme Court recognise that in a narrow category of case, naturalisation obtained by deception would be a nullity?
My lady, yes, but the category that this case falls into was recognised because if one looks at the facts of
No,
this,
I understand that.
yes.
But you seem to be saying that Hysage decides something which is slightly broader, and it in fact does decide.
My lady, I apologise. My lady is right. The decision in Hysage relates to a category of fraud, which is the same sort of category that we have here, and decides that that doesn't render the status granted a nullity from the outset. It remains effective until statutory powers are exercised. The result of all of this is not that deception is rewarded. Deception still leads to revocation. If it is criminal offending, it still can lead to deportation. It does, of course, have an adverse impact on the appellant's status, as we've seen in this case, because his ILR was revoked. He wasn't granted any form of leave thereafter. But what is at stake here is the construction of a statutory provision, and the appellant's submission. Just because leave that has been granted has been secured by deception does not mean that one takes away the clear meaning of the statutory scheme, which is that where leave is granted, that is effective until and unless it is taken away by virtue of the mechanism provided in the statutory scheme and the scheme of the immigration rules. If I could take my lords and my ladies to the statutory framework.
Of course, thank you.
If I could take you to the supplementary bundle of authorities first.
Yeah, page. I'm looking at it electronically, so if you can just give page numbers, that'd be great.
Yes, I'm grateful. If I could start with page 3.
Yep.
Which is section 1 of the 1971 Act. And section 1(2) makes provision for those not having the right of abode being able to live, work and settle in the UK by permission. If one then goes to page 6, section 3(1) provides for the granting of leave to enter and leave to remain and indefinite leave to remain. Page 17, we have section 4, which again refers to the power, the exercise of the power to give or refuse leave to enter and leave to remain in the United Kingdom. The system of immigration control in the UK is constitutive, and so one has to, it doesn't matter whether one meets the substantive provisions for the grant of leave. It is only when leave is granted that one has lawful residence, and one contrasts that with the system under EU law, which is declaratory, and it doesn't matter if you have the document, one has to satisfy at all times the substantive requirements. If I then take my lords and my lady to page 20, you have offences created under the 71 Act. So at section 24, C1, overstaying is an offence. at page 26, section 24B, illegal working is an offence. And likewise, we have in the main bundle of authorities at page 3, section 24A, which creates the offence of using deception to secure leave to remain. Back to the supplementary bundle of authorities, section 76, which is at page 43, provides for revocation of indefinite leave to enter or remain if the leave was obtained by deception, and that is a discretionary power. And so that recognises the possibility that the Secretary of State will exercise discretion and not revoke. And the scheme does not provide for any other grant of ILR. The grant that had been made previously simply continues if discretion is exercised in favour of the relevant person. That is the same mechanism used at page 35, section 40 of the British Nationality Act 1981.
Sorry, page 35 of what?
The same bundle, my lord, the supplementary authorities bundle.
Thank you.
Section 43, the Secretary of State may, by order, deprive a person of citizenship status where that has been obtained by fraud, false representation, or concealment of a material fact. And my lords and my lady, if I could take you then to section 10 of the 1999 Act at page 38 of the Supplementary Authorities Bundle. With respect to removability from the United Kingdom, section 10(1) provides a person is liable to removal from the United Kingdom if the person requires leave to enter or remain but does not have it, and that underpins the appellant's submission as to the overall framework of the statutory scheme, which is that no matter how you got the leave, whether you're entitled to it or not, in order for you to be removed from the UK, that leave must be taken away from you. And with respect to the particular status that the appellant had and its revocation, taking it away is discretionary, even if the deception is established, so it might well be that it is not taken away. And if it is not, there is no mechanism for doing anything else. That same leave simply continues. In terms of the case law, if I could start with SC Jamaica, which in my submission is the one that is most relevant to the circumstances of this appeal, which is at page 54 of the supplementary bundle. It is right to say that the issue with respect to ground one, which is whether extant leave that has been obtained by deception is lawful residence within the meaning of section 117C4, is not something that has been before the courts prior to this case. There is a decision of the upper tribunal, which is in the bundle with respect to long residence, that treats leave obtained by deception as not counting as lawful residence for the purposes of the immigration rules. It does not consider section 117C4, and I'll come on to that case, one of the reasons for concluding as the upper tribunal did was the way in which the immigration rules are to be construed. The cases that you have with respect to section 117C4 from the Court of Appeal all relate to expanding the meaning of lawful residence outside of its ordinary usage, which is residence with leave to remain. The facts of SE, as pertinent to the issues in this appeal, are set out at paragraph 3. And you will see that he was 10 when he arrived with his mother. They sought leave to enter as visitors on that occasion, but that was refused, and they were granted temporary admission until the 25th of January 2002. So temporary admission for just under a month. They clearly overstayed that grant of temporary admission because it was in December 2002, towards the end of that year, that SC's mother applied for asylum with SC as her dependent. The claim was initially refused, but an appeal was allowed, and indefinite leave to enter was granted on the 9th of October 2003. The finding of the FTT is set out at paragraph 22, at the bottom of page 60. And in particular, at the top of page 61, the first sentence on that page, the start date was the 10th of December 2002, when the asylum application was made. So SC arrived in the UK, was refused leave to enter. Having sought leave to enter as a visitor, the conclusion must have been that he did not qualify for leave to enter as a visitor, bearing in mind that he then made an asylum claim, or his mother made an asylum claim with him as a dependent just under a year later. They cannot have intended to be just visitors, and they overstayed their temporary admission. In the language of the offences created under the 1971 Act, they were overstayers, which is an offence, and also, in my submission, sought leave to enter by way of deception, because there clearly wasn't an intention to enter as visitors. The finding of the FTT was that from the point that the asylum claim was made, so that was after they had become overstayers and after the initial attempt to enter as visitors when they clearly did not intend to enter as visitors, the period was lawful residence under section 117C4A, and the reasoning of the Court of Appeal in relation to that is at paragraph 54 onwards. Paragraph 54 at the bottom of page 66, the court notes that there is no definition of lawful residence in the immigration rules for the purposes of the deportation provisions. Likewise, there is no such definition in the 2002 Act. But the court notes the definition of lawful residence in paragraph 276A, which is the provision relating to long residence. At paragraph 56, it was common ground in the first sentence, common ground that SC would have been granted temporary admission from the date of the application for refugee status. So that's from December 2002, nearly a year after arrival in the UK. And then at paragraph 56, the two interpretations advanced before the court are set out. Paragraph 57, the court prefers the interpretation that is consistent and provides for the circumstances of both adults and children. And it endorses the FTT's finding that lawful residence begins from the date that temporary admission was granted, which is the date on which asylum was sought.
Does it make a difference in this case to that proposition, Mr. Jafferty, that the appellant's application for asylum was refused?
My lady, the appellant's submission is no because of the reasoning of the court. And the reasoning of the court, and I'll come on to what Lord Justice Davis said, which is emphasised in a later case of the Court of Appeal, CI Nigeria. But in my submission, the reasoning of the court was clearly based on consistency, and in basing it on consistency, reliance was placed on paragraph 276A, and that was applied by analogy to
Paragraph
399, 276A, my lord,
Yeah.
of the immigration rules. And so paragraph 57, Lord Justice Ryder refers to two factors driving the interpretation: consistency, which of course points back to paragraph 276A, and that the interpretation should provide for the circumstances of adults and children. And the appellant would say, in the context of the issues before the court today, that the interpretation should provide for the circumstances of everyone affected by section 117C4, and that includes, of course, children. And it might well be that children have been granted indefinite leave to remain in circumstances where they were not the party employing deception because they were with the parent who employed deception.
But the reasoning appears to be that although the definition in 276 capital A open brackets little v close brackets didn't apply, it should be applied by analogy.
Yes.
And if that's right, that is tied to temporary admission within section 11, ... where leave to enter or remain is subsequently granted.
Yes, my lady. And in this case, although refugee status was refused,
Oh, I see. You're saying
status was granted.
appellant got exceptional
Exceptional
leave,
leave, my lady, yes.
on the basis that he was a child, when in fact he was already an adult.
And I'll take my lady and my lords to the case of Bokqui, which is a long residence case. But it's clear from that case that it isn't the merits of an application that is pending when temporary admission is granted that drives the way that 276A works. It is whether you are on temporary admission, and at the end of that period of temporary admission, you benefit from leave. And in fact, it might be worthwhile, as we're looking at this point, to go to the Secretary of State's own long residence guidance, which this is at page 168
in
of the Supplementary Authorities Bundle. And the example given on that page shows how the immigration rules, as they then were, treated temporary admission. And again, as we're dealing with the temporary admission point, if I could take my lords and my ladies to page 133 of the same bundle.
Sorry, which page?
133,
Thank you.
paragraph 23. The first sentence sets out what was common ground, which is that temporary admission followed by a grant of leave results in that period counting towards lawful residence. Turning back then to SC Jamaica, page 69 of the bundle and the judgment of Lord Justice Davis. At paragraphs 70 to 73, we have the observations and reasoning of Lord Justice Davis. The most important paragraph in my submission is paragraph 73. While there is reference to the sense of acknowledging a pre-existing status in terms of refugee status, which was the facts in SC Jamaica, the conclusion of paragraph 73 in the penultimate sentence is overall, albeit with some hesitation, I consider that the approach taken in paragraph 26AB can and should be applied by analogy to the present context. And if that does not represent the wishes of the government, the remedy is to provide a definition of the phrase for the specific purposes of paragraph 399A. And the appeal is allowed for the same reasons given by Lord Justice Ryder. In my submission...
And I see Lord Justice Henderson agreed with both judgments.
My lady, yes.
Yeah, that's helpful.
And so the essential reasoning in SC Jamaica was not that it made sense to treat that period as lawful residence because it reflected a pre-existing status. It was applying by analogy the requirements of paragraph 276A, and that was for the purposes of consistency of application within the rules. And a clear statement by Lord Justice Davis that if that did not represent the wishes of the government, it could be changed, but there has been no change.
Can you take us to the then paragraph 276, because I know it developed in various iterations of the rules. Is it in SC? My
lord, yes. We have the actual rules at page 50 of the supplementary. They were the period during which SC Jamaica was heard and decided. So it was. This is
page
the version.
50.
My lord, yes. And the meaning of lawful residence is at the bottom of page 50. And B2 clearly would apply in relation to ground 2 to the facts of this case.
So 276A and then B.
The definition of lawful residence. And my lord, that of course operates distinctly from the disregard provisions that were the subject of a number of cases and caused so much difficulty, because in the disregard cases what was happening was when leave came to an end, temporary admission was not being granted. So those appellants did not have temporary admission. They were simply relying on the fact that they made an application within 14 days. Even then, that period, which was disregarded, was not treated as unlawful residence. It was not treated as lawful residence counting towards the 10 years. It was simply ignored. And of course, as my lords and my lady have seen, the 71 Act provides that such overstaying is a criminal offence. The next case in time is Hisage, and I wonder if we could look at that, although it is not, of course, a case on lawful residence under section 117C4, and it concerns deprivation provisions. Because of the similarity in terms of facts and the mechanism, it is in my submission useful to look at it, and the appellant's submission is that the principles set out there must apply.
Can we just, before looking at Hisage, can you tell me 276A is gone now, has it?
My lord, yes, the mechanism has entirely changed. So we have now appendices to the rules for long residence, and temporary admission followed by the grant of leave no longer counts as lawful residence. But of course, that doesn't, in my submission, take away the reasoning of the court in SC Jamaica. And if one is applying that reasoning to the scheme as a whole and looking at what was intended by section 117C4 at the time that it was drafted, it must have been, in my submission, part of a coherent system of immigration control, which included the way that the immigration rules worked. And of course, this relates to ground 2. There is absolutely nothing in the rules to suggest that residence granted or permission to remain, leave to remain, indefinite to remain granted and not yet taken away is considered to be anything other than lawful residence. The reliance the upper tribunal placed to reach the construction that it did was entirely on the fact that there had been deception, and that deception being a criminal offence, it ought not to be able to benefit a person, so that that cannot be counted as lawful residence. In my submission, one of the difficulties with that approach is that it doesn't consider the other criminal offences and the way that the statutory scheme deals with the other criminal offences. And I'm talking about the immigration offences of overstaying and working in breach of conditions.
In Hoke, there is a brief reference to if you're working in breach of conditions, that wouldn't be lawful.
My lord, I would need to find that.
I'm pretty sure there was, but because after you'd all very kindly cooperated and sent it through, I read them last night. Yeah. a breach of immigration law includes not only presence in the UK without leave to remain, but also, for example, working in breach of conditions of entry.
My lord, yes, that is the definition of breach of immigration laws.
Yeah.
In the immigration rules. Whether that has an impact on lawful residents becoming unlawful for the purposes of 276B is not something that was considered in Hock.
No.
And it is something that needs to be considered. Coming on to the upper tribunal decision of Hay, which is in the bundle, which is a recent decision and says that residence obtained by deception does not count when calculating 10 years continuous lawful residence. That's the construction of the rules that the upper tribunal has reached in a recent decision. But that does not consider the fact that the reasoning, if extended, would mean that anybody in breach, including an overstayer, cannot benefit. And the long residence rules, of course, previously provided for persons that had overstayed but applied within 14 days to still come within the rules. And my understanding is the current version also maintains that provision. And that, in my submission, is the difficulty when one is simply looking in isolation at the offence created in the 71 Act of using deception to gain leave and reasoning from there without looking at the scheme as a whole and looking at how that reasoning would follow through to other circumstances, one reaches a conclusion that doesn't fit well within the scheme. It leads to, in my submission, incoherence and inconsistency.
Well, it might or it might not, but the upper tribunal is not there to decide hypothetical cases that might occur in the future. It's there to decide the issues that are before it on the facts before it. So I'm not really following this criticism at the moment, I'm afraid.
My lady, I will come on to the decision. Of course, it is there to decide on the facts of the case before it, but it decided it on the basis of a construction of the rules that did not take into account the impact in other scenarios. And as the court said in SC Jamaica, an interpretation that flavours consistency and deals with all categories is one that was favoured there. And one has to take into account how that would impact other applicants and other scenarios when one is construing the rule. Applying the rule, where there is no doubt as to the way that it's to be applied to the facts, is of course a different matter. But when one is construing the rule in a certain way, one has to be careful as to what the consequences of that construction would be for other scenarios when deciding what was intended. And that intention, of course, must be coherent within the overall scheme of the rules.
But there's a distinction between living your life in a way that involves you committing an offence under the 1971 Act and getting your leave by committing a criminal offence. I think that might be a relevant point, mightn't it?
My lady, it might be, but one has to look at the language of the rule and the language of the statute to see whether that is what was intended. And if it was intended to differentiate between those two types of criminality, and that is the reasoning, then yes, I accept that. There might be a difference because one is penalising the criminal offence that led to the grant of leave. But if there is no such reasoning and one is simply saying the fact that you've committed a criminal offence means that you should not be able to benefit from that period, one might also say, for example, that somebody that has spent some years committing a criminal offence because they've worked in breach of the conditions of leave that they were granted, well, that period ought not to count as lawful residence for various purposes under the rules. That might also be something that is said against overstayers. But of course, the rules make specific provision for overstayers to be able to regularise their situation if they make an application within 14 days. And one has to take account of all of those provisions so that the interpretation is consistent and coherent within the overall scheme.
I see.
If I could take my lords and my ladies to Hisage.
Yep. Supplementary authorities.
Supplementary authorities bundle, the case begins at page 71.
Thank you.
The facts of Mr. Hisage are set out at paragraph 4. And they are virtually identical to the facts in this case. when the fraud came to light, the consequences are set out at paragraph 6. By that time, both appellants had succeeded in obtaining British citizenship.
His arch is all about the nullity or sort of, removal, void or voidable.
My lord, yes. The reasoning, so we have the previous case law set out at paragraphs 9 to 15, the Secretary of State's position at 16 to 20, and it's paragraphs 18 to 20 that are particularly relevant. I could ask my lords and my ladies to read those paragraphs. My lords, my lady will note that at paragraph 19 in the last sentence, in those cases, it was never contended by the Secretary of State that the grant of ILR was nullified. The reasoning here, and the logic, and the consequences in my submission must apply to the consequences of revocation pursuant to section 76. It is the same mechanism, discretionary revocation. It is, as you can see from the facts of Hisage himself, exactly the same set of facts. It's just that Hisage's fraud went on for longer and was, in one sense, more successful because he got to the stage of acquiring British citizenship. But if that fraud, a fraud that went on for so long, does not result in everything that comes before it being nullified, and of course the consequences of nullification would be the knock-on effect on third parties, and in this case in particular the children that were born to Hisage. And my lords and my lady will see that the order proposed in that case, which is attached to the judgment, expressly provides that...
Where's that?
That
The
follows
annex.
on, it's the annex, my lord, so it starts at page 76.
Yeah.
And my lords and my lady will see that it recites the respondent's acceptance as to the children's statuses acquired as a result of the British citizenship obtained by fraud not being affected. And it would be, in my submission, inconsistent to apply a different regime to ILR obtained by fraud. So that if, for example, the appellant's children had acquired British nationality because the appellant was resident in the UK with ILR, applying the reasoning in Hisage, their status should not be affected. And it would, again, be inconsistent and, in my submission, incoherent for the statutory scheme to, on the one hand, say, well, that residence is not lawful residence, but on the other hand, the residence to be effective in rights being accrued by children of the appellant.
But that's effectively what happened in Hisage, that by not treating it as a nullity, the children were protected, but Mr. Hisage was liable to have his citizenship removed and deported.
My lord, yes, and the appellant does not contend that there should be another outcome here.
No.
All he is saying is that for the time that I had ILR, you must count that as lawful residence, and for the purposes of section 117C4A, I should be considered to have been lawfully resident for most of my life in the UK. And if I'm able to meet the other requirements, then there is an exception to deportation that I satisfy. If I'm not able to meet those other requirements, then of course the exception is not made out. It's not that he's seeking to benefit, except that the residence that was in accordance with the law is considered to be lawful residence.
Thank you.
The next case.
Sorry to interrupt again, Mr. Jafferty. Has anyone suggested that the grant of ILR in this case was a nullity? Is that part of the reasoning
My lady,
of the tribunal?
that is not what is being suggested, but in my submission it is inconsistent. And again, it leads to uncertainty and incoherence within the overall scheme to say that the ILR is not a nullity. The ILR was effective to grant rights to third parties, but it is not lawful residence within the same statutory scheme. And if one looks, for example, at Section 76 of the 2002 Act, if the Secretary of State had decided to exercise discretion and not revoke ILR, and she did not in this case, but there will be cases where she does exercise that discretion, what is the effect of that? There is no mechanism within the Act that says, well, when discretion is exercised, the fraud having been discovered, we will then make a fresh grant of ILR. It's the same grant of ILR that continues. Does that mean that from the point of the exercise of discretion, residence is lawful for the purposes of Section 117C4 and prior residence is not? In my submission, again, it causes an anomaly because the statutory scheme itself says you can simply leave the ILR in place. But to say that that same ILR is not lawful residence for another part of the same statute leads to inconsistency and incoherence. The next case is CI Nigeria, which is in the main bundle of authorities at page 156. The main finding in rejecting the appeal is at paragraphs 38 to 39. And that is that there was no evidence in that case that temporary release or temporary admission had ever been granted. And therefore the submission that that period should be counted as lawful residence fell to be rejected on that basis alone. The court does go on to look at the meaning of lawful residence, lawfully resident, at paragraphs 40 to 43, and look at the position of successful asylum seekers at paragraphs 44 to 48. However, in my submission, that reasoning is clearly obiter, with the main and operative reason for rejecting the appeal set out already at paragraphs 38 to 39. The reasoning at paragraph 40 would appear to be at odds with the operation of paragraph 276A of the rules, and therefore at odds with the core reasoning in SC Jamaica, and also at odds with paragraph 23 of EIKI and the way that the temporary admission provision in 276A operates in the long residence rules. And at paragraph 48, concluding this section of the judgment, the court does say that it is not necessary or pertinent to pursue this whole question of interpretation further, because SC Jamaica is binding precedent, and what matters for the purposes of that appeal is that there is no warrant for extending the ratio to the circumstances of that case, the particular case before it. And of course, in the particular case before it, there simply was no evidence that temporary admission or temporary release had actually been granted. If I could take my lords and my lady to the decision under appeal, which is at, the bundle isn't paginated, it's in the core bundle. And the reasoning is set out at paragraphs 12 to 17.
What page is this?
It's if one look at the PDF, it's page 22.
Thank you very much.
There are three reasons why the upper tribunal found that leave obtained by deception ought not to count as lawful residence for the purposes of section 117C 4A. Those are set out at paragraph 15. The first is that obtaining leave to enter or remain by deception is a criminal offence. And as I've already submitted, if that is the line of reasoning that has been adopted in order to construe section 117C4A in this way, one also has to apply that to other criminal offences created by the 71 Act, and the pertinent ones that would give rise to doubt as to a person's status, notwithstanding having leave.
I don't follow that, Mr. Jafferty, because what the upper tribunal says is, therefore, while the appellant had been granted leave by respondent, he had not obtained it lawfully. That reasoning does not apply to a person who has leave and works in breach of their conditions. It's a totally different situation.
My lady, what I would say about that are two things. First of all, that one is looking at section 117C4A. There is nothing that suggests that one has to look at the way in which leave has been obtained. It's simply, have you been lawfully resident? And the system in the UK, the domestic system, is you're granted leave, you have leave. Even if you cease to qualify, so for example, somebody might come to the UK as a spouse, granted leave for 2.5 years as a spouse. Within months of arrival, the relationship might break down permanently. They might be divorced within 6 months, but that leave continues until it is either taken away or it expires, and that is not unusual, and that is the system. So if leave was obtained by deception, there is nothing in my submission in the rules or in the statutory scheme that suggests, and I think it's of course accepted by the tribunal and the respondent, that that does not nullify the leave. And if it does not nullify the leave, how can it on the one hand be permission to remain in the UK lawfully, and you cannot be removed, so removability is not on the cards until it is taken away, but on the other hand, under the same system of immigration control, the same statutory scheme, it's counted as not being lawful residence. That, in my submission, is entirely contrary to the plain language used in section 117C4A. The second point is that I accept that if one is focusing on the fact that the leave was obtained by deception, then there is a distinction. But if one is focusing on criminality,
But we're dealing with the actual reasoning of the upper tribunal, not its potential reasoning or possible extensions of its reasoning. And it seems pretty clear to me, provisionally at any rate, that what the upper tribunal was focusing on was the way in which the leave had been obtained.
my lady is focusing on the second sentence. I'm perhaps placing more emphasis on the first sentence. But the point is that it is the criminality.
Well, the two sentences are linked by a therefore, so the conclusion that is drawn by the upper tribunal from the first sentence is expressed in the second sentence.
Yes, but my lady, it is linked to the criminality in my submission. Otherwise, one simply doesn't need to mention the fact that it's a criminal offence. You see, you've obtained it by deception. It's been taken away from you. You should not be able to rely on it. So my submission is the criminality is important. I think if I read the Secretary of State's case correctly, the Secretary of State emphasises the criminality. But if we're going to look at criminality, one has to look at other criminality.
Well, one doesn't, because the focus is on the particular type of criminality that happened in this case.
My lady, my submission is that when one looks at the provision in question that we're interpreting, there is nothing to suggest that that is to be read in conjunction with types of criminality. And if it is to be read with types of criminality, why should somebody that has lived here and breached the conditions of leave, with that amounting to a criminal offence, be treated any differently? And that would apply to somebody that
Well,
has...
that's a rhetorical question that we don't have to answer.
My lady, in my submission, one has to grapple with it when construing the provision.
I see. All right.
So that is the first strand of reasoning. Second, that it was unlikely that in enacting section 117C4A, Parliament would have intended that leave obtained in this way would be counted as lawful residence. That, in my submission, fails to take account of the fact that that is the way the statutory scheme works. And there is nothing to suggest that Parliament intended in section 117C4A that this should operate as an exception to the way that the rest of the scheme, including under the rules, the rest of the scheme works.
But doesn't the judge in that second example go on to look at the public interest considerations that underpin the Act, which he has earlier referred to at paragraph 9, where he refers to the overall Parliament's view was that the deportation of foreign criminals is in the public interest. And so this is, as it were, attaching to that overall arching public interest, isn't it?
My lord, yes, but of course the foreign criminal in this case, and in all cases such as this, is not being deported because of the deception. Is being deported because of other criminality. And so it is, of course, absolutely right that the statutory scheme in Parliament does not, well, it provides for deportation. If there is criminal offending, deportation is the default outcome. One has to then establish that there are exceptions. But the exceptions are there. And the exceptions do not say that just because you've had leave that was obtained by deception, that leave doesn't count as lawful presence. One would expect, especially when one comes on to look at NM, which is considered by the upper tribunal at paragraph 13, NM, of course, had been decided prior to the introduction of section 117C4A. It was always a part of the statutory scheme, but if you had leave, it continued to exist in your residence in the UK and presence was lawful. You were not removable until and unless that leave was taken away. Now, had section 117C4 intended that lawful residence should mean something other than it was understood to mean everywhere else in the statutory scheme and in the rules, one would expect that Parliament would have said so. And in my submission, when one looks at the words, the language of section 117C4, there is nothing to suggest that Parliament intended that lawful residence was to mean something different to what it means everywhere else in the statutory scheme. And in my submission, there's nothing that has been identified by the Secretary of State or the upper tribunal that suggests that this meaning of lawful residence comes from any other part of the scheme. Lawful residence, once you've been granted leave, you have leave. Until that is taken away, you're entitled to continue to reside here, no matter what it is that you've done. Even a foreign criminal, if a foreign criminal has leave, that leave remains extant until a step is taken by the Secretary of State to make a deportation order. It's only at that point that the leave comes to an end. And interpreting Section 117C4A in this way means that there is internal inconsistency and there is incoherence in my submission. And I go back to the core reasoning in SC Jamaica. Such a decision would be at odds with the reasoning in SC Jamaica. It would, in my submission, also be at odds with the outcome and reasoning in Hisage, albeit in the context of deprivation. But it is the same scheme, taking away status that has been obtained by fraud or by deception. And that is not to say that one gets away with the fraud or the deception. There are consequences when one uses deception. And the appellant has, of course, already been visited by those consequences because ILR has been revoked. He has no status. If he is going to successfully resist deportation, that will not reinstate ILR. It will mean that he has leave for a limited period of time. That leave will be constantly reviewed. So it isn't the appellant's case that one is forgiving or overlooking the fact that there was deception. But when one is construing this provision, one has to construe it in a way that is consistent and coherent. And in my submission, one cannot, from the language of the provision and the statutory scheme as a whole, get any intent that leave that had been granted means anything other than leave and lawful permission to be in the UK. And of course,
by law, as Lord Justice Ryder referred to it in SC that you just referred us to.
my lord, yes, and in Akinyemi, which I haven't taken my lords and my lady to, but which is addressed in the skeleton, and no doubt my learned friend will take my lords and my lady to Akinyemi. But in Akinyemi, the focus was on removability. And again, in this case, there was no removability until the ILR was taken away. And if I could take my lords and my lady to the supplementary bundle of documents, the 37-page bundle, you will see from the decision-making, the sequence of decision-making in this case.
This is the only bit we didn't get electronically, I think, isn't it?
I apologise, my lord.
No, it doesn't matter at all, as long as we're all looking at the same thing.
If I could take my lords and my ladies to page 10 first.
So the Home Office's decision.
The decision to revoke, and
Yeah.
You will see from the first sentence under the subheading reasons for revocation, a decision has been made to revoke so that it expires with immediate effect. And that is something that is not contentious. I don't think that the leave expired from the point of revocation and there was leave in place at all times prior to that. There is detailed reasoning thereafter, and I think it's also pertinent to look at the bottom of page 14 and the top of page 15, circumstances where the policy, the Secretary of State's own policy, would suggest that revocation of ILR is not appropriate, and that is where deception comes to light more than 5 years after the deception. And so there will be cases where the deception is overlooked on a discretionary basis and the person who has obtained that leave by deception continues to benefit from ILR. And that is the same ILR that was granted as a result of deception. Discretion has been exercised. What does one do then when applying section 117C4A if lawfully resident means residence based on no deception, when the policy itself was saying, well, you can continue to stay Does one treat the entire period of leave as unlawful residence? Does one take the point in time where discretion was exercised as the point when lawful residence began? These are uncertainties that, in my submission, are not warranted by the way that the scheme works overall and the way that the Secretary of State's own decision-making proceeds. And then you have, at the bottom of page 16, reference to another part of the statutory scheme, section 10. The appellant was now liable to be removed. Persons who require but no longer have leave to enter are liable to removal pursuant to section 10. And then you have, at the bottom of page 17, language that is consistent with the way that the system of immigration control and the statutory scheme works. Consequences of illegally staying in the UK, which would be from now going forward. And the last sentence of that first paragraph before the bullet points, or the last two sentences, if you decide to stay, then your life in the UK will become increasingly more difficult. For example, some of the consequences of not leaving immediately will be that, and then there's a whole raft of consequences and potential criminal offences. That also, in my submission, shows that notwithstanding that the leave was obtained by deception, the quality of residence during the period where that leave was extant was very different to the quality of residence where there is no leave. And the letter itself points out how difficult life will now become. And that is my submission, is relevant to the underlying purpose of section 11C4A, which is of course an Article 8 compliant outcome. And it treats leave with lawful residence in a different way because the quality of that leave in terms of the private life and family life ties established is very different to staying in the UK with no leave, even with temporary admission. The quality of life when one has leave is, in my submission, very different. And then if I could take my lords and my lady to page 36. This is a subsequent decision to be read in conjunction with the initial decision.
So the initial decision,
the one that we looked at just now, my lord, the revocation
was
decision.
11th of November. Yeah.
And so on the 17th of March 2021, a response to the section 120 representations made by the appellant, which are in this bundle as well, it rejects those representations with respect to the decision to revoke ILR, but in the final paragraph says that this is not an assessment of your human rights claim. Revocation remains appropriate, but these representations will be considered in the context of private life when his removability from the UK is assessed. And that chimes with the focus in Akinyemi of section 117B, which is removability. And that, of course, was expanding the meaning of lawfully resident, but focusing on removability, so that somebody that doesn't have leave, but didn't need leave because Akinyemi was born in the UK and was not removable, that period ought to be considered as lawful residence. And of course, the same applies here. He was not removable until this stage when his ILR was revoked. That is the Secretary of State's own position, and that is clearly correct in light of section 10 and the statutory scheme overall. And therefore, where a person is lawfully resident, establishing ties in the normal way that a lawfully resident person would, not removable, why should that presence not be considered lawful presence within the meaning of section 117C4. And that, of course, is without taking away from the fact that the fact of deception will have consequences and will be considered by the Secretary of State. It's not that one simply takes away the fact of deception and pretends that there was no deception. That will no doubt form part of the decision making. And when one looks at section 117C4A, of course, it is not enough that you have been resident in the UK for most of your life. There are two further steps that must be followed by the decision maker, and two further high hurdles that an applicant must overcome in order to meet the exception. The only issue that arises on this appeal is whether at the first stage of considering the exception, does this residence count as lawful residence? It's not an emotional issue, and the exercise of discretion imports a degree of emotion and a degree of culpability in terms of your previous conduct. This is simply about the legality of your residence. And under the statutory scheme, if you've been granted leave, your status is that you are legal. And that is, I think, very clear from section 10, and very clear from the Secretary of State's own decision making, which shows that you cannot remove until that status has been taken away.
Can I just ask a factual question, Mr. Jafferty, about the supplementary bundle?
Yes.
The first letter in the supplementary bundle is the letter refusing your client's application for naturalisation. It refers to a caution in
Yes.
September 2012, which was not declared on the application form. What was the caution for?
My lady, I think this might well be addressed in the representations. And I'll just have a look because it's not something that I am aware of off the top of my head.
I read those a bit.
My lady, it's dealt with at page 7
Yeah.
of the bundle, and the letter says in the, I think it's the third and fourth paragraphs on that letter.
Yeah.
And it simply says, client was unaware that he was in receipt of a police caution. He would like to put it on record that he does not want the Home Office to consider that this as him being deceptive in any way. So I'm not sure whether we then get to what the caution was for.
Oh, I see. All right. Thank you.
And it's not referred to, I think, in any of the decision letters either.
No, I hadn't. I was just curious about what it was about.
Unfortunately, my lady, I cannot help any further
All right.
with
Well,
that.
thank you very much.
My lords, my lady, I think that covers all of the points in relation to the 2 points of construction.
Yeah.
We've already dealt with ground 2 in terms of looking at SC Jamaica, looking at the long residence policy, the rules, and how that period was treated in EEKI. I've dealt with CI Nigeria and what is said there, which seems to suggest that the period until he was granted exceptional leave should not count as lawful residence, but in my submission that is inconsistent with the binding authority on this point, which is SC Jamaica. And just to summarise the appellant's submissions on the construction point,
Yep.
leave exists until revoked, that is the overall scheme. Revocation is prospective, it is not retrospective.
Hang on, don't go too quickly. Revocation prospective, yeah.
Lawfulness in the overall scheme follows from your extant status, the status that has been granted by the Secretary of State.
Follows from status which was leave.
My lord, yes, and that continues until and unless it is taken away. The fraud consequences still apply and are catered for in the statutory scheme. They're catered for in the rules, they're catered for in the statutory provisions. So it isn't that this is a case of somebody getting away with it. And of course, even if it is established that that residence is to be counted as lawful residence, that is simply the first step in a very demanding three-step process. Hisage confirms that where there is no nullity and no retrospective effect of revocation, the consequences of third parties must still endure. And that, of course, leads to the final point, which is that construing section 117C 4A in the manner contended by the upper tribunal and by the Secretary of State results in overall inconsistency and incoherence. And SC Jamaica interpreted the provision primarily on the basis that there should be consistency. The second point, of course, in SC Jamaica, that it ought to cater for adults and children alike. And I've already made submissions in relation to the impact on children who are innocent parties. If a child benefits from ILR because of the deception of a parent, the reasons given by the upper tribunal as to why the party to the deception, the person that practiced the deception, ought not to benefit by being considered as being lawfully resident, that surely that reasoning cannot apply to an innocent party. But if the provision is interpreted in the way that is contended by the tribunal and the Secretary of State, the result would be that innocent children will be affected by it. SC Jamaica was such a child, and had, on the facts of SC Jamaica, leave been secured by deception by the parent, SC Jamaica on this construction would not have been able to bring himself within section 117C4 or, of course, the application of section 117B. And it is important that one recognises that if lawful residence does not include residence obtained by deception for the purposes of section 117C4, that must also apply to section 117B. And Akinyemi was a case about 117B, and that would again result in an impact on innocent third parties. So, for instance, if an appellant who has obtained indefinite leave to remain by deception then establishes a relationship with a qualifying partner, with the qualifying partner being entirely unaware that the leave has been obtained by deception, that relationship and that family life would need to be given little weight in accordance with section 117B. And that is why in my submission it is important to consider the overall coherence of the system of immigration control and the way that that system treats leave that is granted by the Secretary of State. Of course, my lords and my lady have my skeleton argument.
Yes, we've got all the very helpful materials.
I'm very grateful. Unless there is anything further that I can assist.
In paragraph 15 of the upper tribunal's decision,
Yes.
there were three reasons given for the decision. I don't read what the judge said at 14 and 15 as indicating that any of them were, as it were, dependent on the other. What do you say about the third ground for the decision, the extirpe causa ground, and how that impacts on what you've told us already about the coherence of immigration control and the way in which you've interpreted
Yes.
the Act to advance your case?
My lord, that decision is in the main authorities bundle at page 28.
Yes.
The facts in that case were very different because the facts there were that an applicant who had established a business whilst working unlawfully in the UK was seeking to rely on the business established whilst working unlawfully to meet the requirements of the rules. And it was in that context that the tribunal found that you cannot benefit from a business that is established when you're working in the UK lawfully. To apply that reasoning to section 117C4, of course, requires one to interpret section 117C4 by reference to this principle. One has to consider whether it is the fruits of the deception that is being relied upon. And in my submission, when one looks at it overall, and I accept that, of course, the most difficult part of this case for the appellant and the most persuasive part of the case for the upper tribunal and the Secretary of State is the instinctive reaction that one cannot benefit from something that has been obtained by deception and by criminal conduct. I think the appellant recognises that. But one is interpreting Section 117C4, a statutory provision. And in my submission, one has to look at that statutory provision in the overall framework. And the real question is that what Parliament intended? And in my submission, it cannot be, and the uncertainty that would flow from it, because if that is the way in which one interprets the provision, one of course gets different outcomes for people that have obtained the leave by deception based on their culpability. And so, my lord, the example that I gave, where a child that is not a party to the deception, if that is the only reason for finding that the section should be interpreted in that way, then one would have to have an exception for that person, because that person didn't actually use any deception. And in my submission, it becomes unworkable. There's nothing to suggest that Parliament intended that what is a very straightforward provision and the use of a very commonly used and straightforward phrase that is commonly understood across the whole system of immigration control should suddenly be interpreted with such factors in mind and the uncertainty that that produces. I hope, my lord, that is of assistance.
Thank you.
Thank you very much indeed.
I'm very grateful, my lord.
Mr. Brooks, want to say anything?
No, my lord.
Thank you very much. Mr. Tabori.
Thank you. I'm going to make my submissions in 3 stages. The first will be, the proposition of the first will be that the natural and ordinary meaning of the words used in section 117C4A, read in their surrounding context with regard to their purpose, support a interpretation of that provision as excluding residence that is obtained by deception. The second stage of the 3 will be to look at the Court of Appeal authorities, in particular CI Nigeria, and the last will be to look at the long residence rules analogy in the rules.
Thank you.
With the statutory construction, I'm going to work outwards from the provision. So the text itself of 4A, we submit that the natural and ordinary and plain meaning of lawful residence doesn't include leave obtained by deception. And that is really just a matter of what we submit the meaning is. But I would add to it, what my learned friend says is, what he accepts is the instinctive reaction. That instinctive reaction weighs in at this point as to what is the natural and ordinary meaning. Secondly, moving outwards to the surrounding subparagraphs, so 4B and C, their relevance is that they wouldn't capture the deception. My learned friend refers to the very demanding 3-step process, and I agree it's demanding, but the deception wouldn't come in under any of the others. So B is social and cultural integration, the meaning of which is helpfully defined in CI, which is in the first authorities bundle, tab 12, beginning page 156, paragraphs 57 and 58, which are on page 171 of the PDF.
171.
Yes, my lord.
Thank you. And what are we looking at? CI.
CI, yes. Reference in, so 57 confirms that we are talking about social and cultural integration, just to orientate ourselves, but the real definition, if you like, is at 58, where if you'd like to read to yourself what is said there about the meaning of that from the start of it. and then 77 applies it to the particular facts of that case in a way that's a bit more succinct. That's on page 176.
Paragraph 77.
Yes.
Yeah.
Paragraph 77, my lord, yes. 76. Upbringing, education, employment history, history of criminal offending and imprisonment, relationship with family and friends, lifestyle and other relevant factors. CI was at the time of the hearing socially and culturally integrated. So that's not about, that doesn't capture whether the leave obtained was obtained by deception or not. And of course, in terms of 117C4C, that is about obstacles to reintegrate in the country of origin, country of return. So that's obviously it's not going to come in there either. So that means that for the medium offender, the 12 months to 4 year offender, the exception 1, which says that public interest presumption doesn't actually apply in your case, would be determined without regard to the stark fact of the residence having been obtained by deception. So that's just, we say that cannot be the intent, and that militates against the appellant's contention. Thirdly, spreading out further into 117B.
Sorry, can you just go back to what you say your last one was? So that is, if the criminal offence you commit is obtaining leave by deception, and you're only sentenced to under 12 months, then there's no public interest in removal.
The offence would be what had led to the deportation action.
Yeah.
But in considering the Article 8 question, where you look at this exception 1 in 117C4.
Well, that assumes that completely obliterates the court's ability to look at all other relevant factors, which I'm not sure it does.
It's not entirely clear where else it would come in. If you are a medium offender, it's exception 1, unless you're relying on family life, for instance, in which exception 2 might be relevant. You're not looking at 6, because you wouldn't have to go that far. You could just rely on 4. And it would mean that the deception, for purposes of your lawful residence, not for purposes of your offence. Your offence is what gets the ball rolling in the first place, and triggers, if you like, 117C4 in the first place. But for purposes of weighing up the public interest in not removing you, weighing up the weight of your private life, deception just wouldn't be able to come into it.
Thank you.
Because, of course, the public interest in your removal is already supplied by the fact of the sentence. The third sub-point, if you like, within this sort of statutory construction first stage is, as I say, 117B4. That is the first of the 2 little weight provisions, and it's the one that concerns private life, what we're talking about in this case.
No, we haven't got 117B.
Unfortunately not, my lady, but you can find it in Akinyemi, amongst other places, if I could use that one. It's on page 142 of the authorities, first authorities book.
My lady, we do have a paper copy if that would assist.
Very
Yes,
helpful.
that would be very helpful.
Thank you very much.
So, subparagraph 4, little weight should be given to a private life that is established by a person at a time when the person is in the UK unlawfully. So, of course, this is the general position, not just for foreign national offenders, but where we are talking about deportation and FNOC is relevant as well. But my submission on this is that it would be contradictory if little weight were to be afforded to private life established when in the UK unlawfully, which is the case here. If you've obtained deception to obtain it, it's literally a criminal offence. If when it came to C4A, it was satisfied by
Well, that assumes your construction to be correct, because Mr. Jappaji's response to this would be, well, he's not unlawfully in the United Kingdom because he's got leave.
Yes. Well.
So all you're
Yes.
doing is just pointing to another provision which we would have to interpret.
Yes.
I accept consistently, but I'm not sure that pointing to it and saying, by the way, that will need to be consistent necessarily takes us any further forward.
Yes. Well, perhaps it might be clearer as we move on to the next stage, my lord, which is to look at the wider immigration acts, specifically the 1971 Act, the relevance of which is underlined by 117A, which states that Part 5A concerns.
So where are we in the authorities?
For 117A, I'm not sure it's
in the loose.
it's in the loose.
It's in the loose.
But
thing that's just-
117A1 confirms the confirms the relevance of the wider immigration acts. It says this part applies where a court or tribunal is required to determine whether a decision made under the immigration acts breaches a person's right to, etc. So within the 1971 Act, as I mentioned, Section 24A.
Sorry, 117A1. Why does that refer back to the Immigration Act?
It says that this part, so the provisions we've been looking at in 117C, but also B, apply where the court or tribunal is required to determine whether a decision made under the Immigration Acts, such as deportation, as an issue here, breaches private or family life under Article 8.
Yeah.
So if it wasn't already sort of an obvious relevant, I mean, my friend referred many times to the broader immigration scheme. I'm just referring to a provision in A that confirms the relevance of those wider pieces of legislation.
Yeah, I'm not sure you needed to.
No,
Fine.
perhaps not. But
So
then,
let's just go and look at the relevant act and,
Yes, so the
and have your
97
submissions on it.
yes, the 1971 Act.
And where are we now?
So for 24A, it's in the first authorities bundle on page 3.
Yeah, thank you.
Person who's not a not a British citizen is guilty of an offence if, by means which include deception by him, Roman numeral 1, he obtains or seeks to obtain leave to enter or remain. So that's the case here. And then in section 33, which is the interpretive provision, which is in
Hang on, when was this bit incorporated in? Because it says 24A.
in 2000, according to the first footnote, I think.
And does that have any relevance? When was all these alleged offences taking place or offences taking place? He came in 2000, didn't he? What was the provision at the time?
Afraid I don't know if top of my head.
Well, that's one of the real problems with everyone changing the legislation on a 5-minute basis, but it doesn't matter. Let's just get it right.
Yes.
So he arrived on the 4th of October 2000. When was this amendment made?
14th of February 2000.
So this was in force at the relevant time.
Yes.
Excellent. Sorry to
It's a
ask the
relief.
questions, but
No, exactly.
you know, it's one of those things that can be easily overlooked.
Yes.
So 24th of February 2000, and entry was November 2000. Yeah. Right, now which is the bit you'd like us to look at?
Section 33 of the same Act in the supplementary authorities, page 30 of the PDF.
Was there an offence before the 2000 amendment for obtaining by deception or not?
Well, I have to check. I seem to recall it may not have been spelt out in the same specificity, but it may have been caught in a different way. I may have to for instance, section 24 without the A concerned illegal entry. So, and I mean, I think I would have to do some looking into how it was caught. I'm slightly surprised that it was perfectly lawful before then, but maybe this more specific offence was enacted to avoid issues.
Yeah, I understand that point. So you're asking us to look at entrant, is that right?
Yeah, entrant, exactly, and specifically illegal entrant means a person unlawfully entering or seeking to enter or so the second part, not the breach of the deportation order, seeking to enter in breach of the immigration laws, which obviously includes the offence.
I think he entered clandestinely, didn't he? I've picked that up somewhere. And then he applied for asylum after he entered, and that was the stage at which he started making the deceptive representations about his age and nationality.
Yes. Which may mean this that particular definition doesn't catch him.
Well, he was an illegal entrant, no doubt about that.
But I mean, I understood he had.
Well, the letter on page 10 of the supplemental bundle says, on 4th of October, you entered the UK and claimed asylum.
Yes, so it was at the point of entry. It was subsequent.
Well, I've got a feeling I picked up from one of the letters of representations that he'd entered clandestinely. Let me just see if I can find it. Yeah, if you look at page 22 for the supplementary bundle, these are some representations from the appellant solicitors dated the 17th of November 2020. Under the heading background, paragraph 1, applicant being in the solicited arrival, applicant did not have a visa on arrival. He arrived in the UK clandestinely by lorry.
Yes.
He made a claim for asylum on arrival.
Yes. So yes, I mean, I would submit that that encompasses the type of claim, type of means of remaining that you rely on at the port, as it were, even if it's subsequent to actually landing.
So what are you asking us to take from this provision?
So, so after you come out of A, it then includes a person who has entered in that manner. So therefore, the person who obtains their first form of leave to enter and remain in breach of the immigration laws is an illegal entrant, not just at the point of that entry, but having done so, has the past perfect tense, which would therefore apply to the appellant.
Yeah, well, I don't think Mr. Chatterjee would contradict you on that. His point is that once you get leave, then it makes you lawful. He's not arguing about the 4th of October 2020.
Well, I would submit that can't be the case. I mean, you can't. If you come within that definition, that definition isn't subject to the exception of having obtained leave to remain by whatever means. It's simply concerned with the manner of entry. And that continues to apply, hence the has thereafter.
Yeah.
And if the appellant is an illegal entrant within the meaning of that sort of foundational act, then be odd to also find that he has lawful residence.
Well, there are lots of people that enter illegally on boats who are then granted asylum.
Yes, quite.
So
quite.
they then, and the illegal entrance is nothing to the thing.
Yes, I suppose the difference there is they can rely on the substantive entitlement that they hold, as distinct from someone who doesn't have that and solely has the label provided by the 71 Act.
Thank you.
Then turning from the sort of provisions of the Act itself and the surrounding acts to purpose, the first point about purpose is to distinguish what purpose is not. So learned friend referred to the provision in 76 of the 2002 Act permitting revocation of leave to remain and indefinite leave, and also to the section 40 of the British Nationality Act permitting deprivation of nationality, and also to high serge on deprivation and to NM on curtailment. Those are concern a different question, which is the administrative function of removing the particular status, which also occurred here, but is not the purpose and concern of section 117C. So 117C is in the same act, obviously, as the revocation power, so it'd be odd if it were duplicating that function. 117C is about determining whether there is a public interest in deportation. And that involves looking at, because it's about Article 8, the quality of, the weight of, the nature of the Article 8 interests, the private life. And in that question, when weighing up, so it's not a balance sheet exercise in the sense of 117C6, where it's sort of a broader proportionality question, but it's built into this. It's saying that, okay, on the deportation interest side, you've got what the acts already supply, but on the private interest side, these are the three set criteria. And it would be very strange, I would submit, that if 4A sought to treat equally leave obtained by deception in the same way as leave that was not, it would be seeking to effectively, within that broad public interest question, as my Lord Justice Cobb raises, it's not about the sort of administrative question of removing a status, but the light in which particular residence is viewed, particular private life, it is to be seen. It would be to effectively reward that deception, and the longer you maintained the deception and held out, the more years you had, the more better prospect of satisfying 4A. The greater analogy, rather, must be with the person who has no leave to remain, and who therefore doesn't satisfy it either. So that's what I say about what the words, the surrounding words, and the purpose say to help you construe this question. Turning to the second stage and the authorities, I could take the court to CI Nigeria.
Yep.
This first authorities starts on page 156. And paragraph 40 on page 166. There, Lord Justice Leggett said, there are more fundamental objections to CI's argument. It makes no sense to treat someone who's present in the UK in breach of immigration laws and liable to removal For example, as in the present case, they remained in the UK after limited leave to enter or remain had expired as lawfully resident in the UK within the meaning of 117C4A, whether or not the person has been granted temporary admission or release pending deportation or on immigration bail. And that's obviously pretty clear of itself, but there's also a sort of broader implication to that it's saying that even if you have a form of document, if you like, if there's a sort of formal thing that's been ascribed to you, in this case, not even because of deception, because none of these three Court of Appeal cases, Akinyemi, SC, CI, concern deception, so they're not, that's why I don't lead with them, if you like. It's saying that that's not the end of it. There's a sort of substantive question at issue as well. And it refers to describe such a person as lawfully resident in the UK as not consistent with ordinary use of language, which is further why I start with the language, and supports tangentially perhaps the upper tribunal decision that we'll look at when we consider the analogy long residence, where the tribunal relied heavily on the use of language. And then later in the same paragraph, going on to page 167, makes the analogy with 117B4, which we've looked at, and refers to Akinyemi, which concerned 117B4 rather than C4A, as in CI in our case. Quote, as Lord Justice Underhill observed in Akinyemi at paragraph 42, that it, in turn, is because, as a general principle, a person cannot legitimately expect to be allowed to stay in a country on the basis of relationships formed and ties created when he or she has no right to be living there in the first place. Juness, European Court made it clear this principle is not displaced where a state tolerates the presence of an alien in its territory, thereby allowing him or her to await a decision on an application for a residence permit. I mean, in this case, it's not a delayed enforcement situation of tolerance, it was simply unknown. So it applies a fortiori.
And what do you say to Mr. Jappaji's point that this is all obiter?
It's not obiter, it's an additional reason, and the importance of it is shown by the beginning of paragraph 40. There are, however, more fundamental objections. The fact that multiple reasons are given doesn't mean that reasons 2 plus are obiter. And then 41, the fact that 117B4 and 4A have a common rationale means that to treat someone who's in breach of a legal obligation by being in the UK and is legally liable to be removed as lawfully resident for the purposes of 117C4A would be inconsistent with the Akinyemi case, which treated such a person as in the UK unlawfully.
So if you're right that this is part of the ratio of CI, you say that's binding on us?
Yes, yes. And then 42 is also very helpful. In particular, well, I'll read it all and we'll get to the bit I say is a useful tool for you in your task. I recognise it's not CI's case that anyone granted temporary admission or immigration for the purpose of section 4A. The question is, however, whether it's good reason to treat the fact that such a person has made an application for leave to remain subsequently granted as bringing them within the scope of the provision. The same test, I would invite you to adopt the same test here ultimately. So just as there's a sort of qualitative question of legitimate expectation, so too there is this qualitative question of good reason to treat it as such, as lawful. paragraph 43, the end of this section on the meaning of lawful resident repeats the legitimate expectation principle, if you'd like to read that to yourself.
And what do you say that's relevant to?
Just that it applies here and guides the answer as well. So in that case, a foreign national whose presence in the UK is in breach of immigration law but is tolerated whilst such an application is pending, and who develops a private life or family life during this period cannot claim to do so with legitimate expectation of being allowed to stay, even if subsequently granted, would say that that applies equally here and the far more strongly for the person who who has used deception to obtain their leave. Just to turn to Akinyemi then, seeing as it was so influential on the SC and CI cases. It's on page, it's tab 11 in the first authorities, and specific passages are on page 151.
Thank you.
And we see what Lord Justice Leggett was referring to. 41. As a matter of ordinary use of language, it seems to me unnatural to describe a person's presence in the UK as unlawful when there is no specific legal obligation of which they are in breach by being here, and no legal right to remove them. So this, as we go into 42, we'll see why that was the case on these particular facts. Third sentence, 42. The reason why it's reasonable to place little weight on private life established while a person's presence in the country has been unlawful is surely that he or she has no legitimate expectation of their continuing presence. So no legitimate expectation means not lawful. So even without sort of going around the houses of section 33 of the 1971 Act and bringing in the definition of a legal entrant, as a matter for the sort of Article 8 question, it has this substantive content to it, which means that it's unnecessary to have specific provisions on deception. And then at the end of 42, as I mentioned, we see why in that particular case that wasn't, that test wasn't met, if you like, by the Secretary of State. Or just as Underhill said, it's hard to see how that policy can apply to the situation of a person born in the United Kingdom to parents who were lawfully present and who in due course became settled, who is legally irremovable and who is entitled to acquire British nationality. Such a person's expectation would be that they continue to live indefinitely in the UK is entirely legitimate. So it's the perfect distinguishable facts.
Only defeated by the Appellant's Commission of Criminal Offences, which subsequently disentitled him from applying for naturalisation.
Yes, I think those are the facts of yes. I'm not going to take you to NM and High Sedge because you'll have seen them. They were NM was concerned with the existence of a power to retrospectively curtail, which is not what's happened here. High Sedge was concerned with effectively common law doctrine of whether something could be nullified by the deception, as my Lady Justice Laing refers. That was only held to be the case where someone had adopted the identity of a real other person, because then it would simply be, as a matter of fact, the case that that real other person hadn't applied for the thing in question. But we're not talking about that either. What is notable about NM is that it was Deputy Upper Tribunal Judge Ockleton who also decided FS Ankara, the case regarding not being able to benefit from your wrongdoing, ex turpi causa principle as it applies in public law. So, of course, I mean, he may have had different things on his mind in those two different cases, but one can see that by his two decisions, the two principles operate side by side and don't contradict. One is about, as a matter of an administrative function, something can be removed and as a matter of the records, and the other is about whether you be able to rely on your wrongdoing. That's, of course, we say relevant here. So the third stage, after looking at some of the authorities, is to look at the long residence analogy. My learned friend's helpfully taken you to the...
Can we just,
Yes.
before we leave stage 2,
Yes.
just on the facts, if you look at page 46, which is the first tier tribunal judgment, paragraph 2,
Which page was it? Lily?
page 46 of the bundle, which I think the court put together, but paragraph 2 over the page for the first tier tribunal judgment. Can I
Yes.
just ask you something about this, because you were talking about legitimate expectations and all the rest of it.
Yes.
It says on the 17th of January 2013, the appellant made an application for naturalisation as a British citizen, and we've seen that. That application was refused on the 8th of February on the grounds of character, giving a false date of birth and false nationality. Is that right, or was it in fact the caution?
The caution that led to the refusal.
Yeah.
I'm afraid I don't know, my lord. I could check.
Well, you can see from the first document in the supplementary bundle is the letter refusing the application for naturalisation, and it doesn't appear to support what's said in paragraph 2, because what it appears to say is that the reason the application for naturalisation was refused was because the appellant failed to declare a caution which he had received when he made the application.
And then you go on, 11th November, ILR revoked due to deception. So how was that discovered?
I have sought instructions on that particular question, my lord. I haven't received it yet, but it may have be amongst what I've been sent since the hearing started.
Okay.
As to how they discovered it, I presently don't know.
And then why wasn't, when you were talking about legitimate expectations and all the rest of it, why wasn't the notice of administrative removal enforced before the conviction?
I don't know. I also don't know that, my lord, as to why it wasn't enforced sooner.
No. If we're trying to have a joined up immigration system,
Yes.
I mean, these are things that judges might comment on. So it would be helpful to have
Yes.
information.
Yes, I mean, I suppose that where that might come in, if it were the case, for instance, that it had been discovered earlier and not acted on, would be an element of tolerating it, of tolerance, which we've looked at in the context of, we saw mention in the references to jeunesse, where it said that doesn't expunge the...
But the reason I ask you specifically, just so that you know about the 2013, what the first tier tribunal judge says, it was seems to have been discovered according to this bit, but not according to the other documents we've seen, that he'd given a false date of birth and nationality, and yet the Home Secretary doesn't do anything about removing his indefinite leave to remain. And that just goes, Mr. Jafferty would say, full circle back to his proposition that you just look at leave.
No, that would just mean that you haven't revoked it yet. It would go to the sort of the administrative revocation question. It wouldn't go to the thing we are talking about, of the substance, the legitimate expectation of the thing itself. The the legitimate expectation wouldn't grow, if you like, in legitimacy by the fact that there hadn't been swifter action on it, because it begins from the outset. So from the outset of obtaining it, there's no legitimate expectation. And I mean, as I say, my Lord, at most it could be that there's some legitimacy grows from saying, I'm being tolerated. It's being tolerated. Nobody minds. But as I say, the jeunesse principle, if to call it that, shows that doesn't affect it.
Anyway, it would be helpful just to have the accurate facts, because this was a bundle put together by the court. We've now got the supplementary bundle, and the supplementary bundle seems to suggest different answers in relation to these points.
So would you like me to make some inquiries of when it was first discovered, the deception?
Well, yes. Well, I mean, just specifically on that point, because that does appear to be inconsistent. I'll ask Mr. Jaffe about it, but it does appear to be inconsistent with what is said on the 8th of February 2013.
Yes, I'm happy to check.
Okay, thank you very much.
And sorry, my Lord, was it also about the caution and the date of the caution, whether the caution was taken into account in during the naturalisation?
Well, that's answering the question, because if you look at paragraph 2, just above paragraph 3, it says, was refused on the 8th of the 13th on the grounds of character, giving a false date of birth and false nationality. We don't know, and Mr. Jaffe was asked about that, what the caution was for. I mean, was he cautioned for giving a false date of birth and nationality? I would think it unlikely, but you never know.
But I mean, the basic point is we seem to have the letter refusing the application for naturalisation.
Yes.
It's the first document
Yes.
in the supplementary bundle, and it is inconsistent with paragraph 2 of the FTC's decision.
Well, unless the caution was for giving the false date of birth. Anyway, goodness only knows.
Seems unlikely.
Oh, yeah. Anyway, sorry to ask you questions
No,
just as you were
no,
about to
please.
leave your item 2, but it was just probably the most convenient point to try and chase that down.
Yes.
Good. So your third point is long residence, you said?
Yes, my Lord. So, though relevant provisions are in the supplementary authorities bundle
Yeah.
at 50, and I think I think my first point just we say something in response to the reliance on the temporary admission provision. That we would say doesn't strengthen the case really, because it's sort of discrete to itself about whether temporary admission becomes lawful if subsequently granted. But the issue isn't here about like in CI or SC, whether a period of temporary admission amounted to lawful residence. It's not. It concerns a far longer stretch of residence. The question is whether the subsequent grant of leave that is referred to in these definitions can, for the different purpose of 117C4A, constitute lawful residence. And the analogy is with CI rather than SC, i.e. a case where it was not subsequently granted, because that has to be seen as the analogy for reasons given in those cases, as well as in the face of the legislation. And a case helpfully found by my pupil, the reported case of Hay in your supplementary authorities at 136, concerns our question, but in the context of this analogous context of long residence.
Judge Mandelia's judgment.
Yes. We could start at 23. which is on page 144.
Paragraph 23.
Yes, my lord.
Yeah,
So
thank you.
the question is not, as Mr. Walsh submits for the applicant, whether the grant of any leave relied on is valid or a nullity. So that's, as I've said, in relation to the distinguishability of NM high surgeon. It is, as Mr. Biggs submits, a question of the proper interpretation of the words continuous lawful residence in 276b(1). It summarises the principles on interpretation of the rules, in particular in Wang, paragraph 30, Lord Brown's, the rules are not to be construed with all the strictness applicable to the construction of statute or statutory but instead sensibly according to natural ordinary meaning. And then 28 on page 145. If you'd like to read that to you.
Yeah.
If you're ready, 29. There's no reason not to give the language of the rule anything other than its plain and ordinary meaning. 30. Please read that to yourself too, and the final paragraph is particularly significant. And then 31, in particular, the third sentence, any other interpretation. (32) says something similar. Just if you'd like to read to 34 to the end, it says to the same effect. So, strictly speaking, it's the case of FS and this case, two upper tribunal decisions that are closer to our facts in that they concern seeking to obtain a benefit through lawful acts and Hay even more specifically, whereas the Court of Appeal authorities are not on our facts, but they do provide, as I hope, useful tools. Good reason to treat legitimate expectation to how you should interpret lawful residence. But ultimately, I do come back to the textual analysis, if you like, of stage one about the plain meaning, and Judge Mandalia uses sort of implicitly and absurd and so on. And I appreciate a lot of that is not as hard-edged as other matters, but as my learned friend himself accepted that about the instinctive reaction, I do submit that in this case, where, at least for Court of Appeal purposes, you are looking at it first, that is a useful guide.
So effectively, I mean, upper tribunal Judge Mandalia is saying is construe the provision to produce an absurd result.
Yes.
Which is a perfectly respectable canon of construction.
Exactly. So I think unless I can help you any further, and I do have those points to take away, those are all my submissions.
Thank you very much. Mr. Jappaji, just before you get into your reply, are you able to help us with the specific point I put to Mr.
My Lord,
Taburi?
I think we might be able to provide some assistance. Mr. Brochwala has helpfully identified a passage at page 4 of the supplementary bundle.
Page 4 of the supplementary bundle, yeah.
The last paragraph, first sentence, which tells us when the deception was discovered.
Oh yes, further checks in September 2019.
It's not clear how those further checks were conducted and against what, and we are trying to get the respondents bundle that was before the first tier tribunal to see whether there was any further information in that bundle. We're also trying to find out what the caution was for, as it might be the caution was for something relating to identity.
Yeah, well, that's the only reason
Yes.
for finding it out, because that trying to make sense of what the first tier tribunal
What triggered
had
this?
said.
Yes.
Because Mr. Brochwala was, in fact, it appeared at first instance, didn't you?
Yes, my lord.
Yeah. So I just wondered if you knew.
Yes.
And so it was 18th September 2019 they carry out the further checks, but it then takes them another year before they do anything about it.
Yes, a year.
Yeah.
A year, about 14 months, I think. Yes, 14 months. And then, of course, there is no enforcement until the criminal offending. And there is also, of course, the fact that human rights representations were made immediately upon the November 2020 decision.
Yeah.
My Lord has seen already the letter in response to that in the supplementary bundle.
So this case is not dealing with any human, was what originally wasn't dealing with the human rights side, and then it all changed when once the
Criminal offending. But for the criminal offending, nothing
Yeah.
would, well, we don't know when something would have happened. Human rights representations had been made, they were outstanding, but nothing had been done in relation to that, and no enforcement action had been taken in relation to that either. My Lord, if I could start with CI.
Yeah.
Which is in the main bundle of authorities, and take, my lords and my lady, first to page 157. Ask if you could very quickly read paragraphs 3 to 5, which sets out the background facts and which shows in my submission that the facts in CI were very different to the facts in this case.
So this is 157.
157, paragraphs 3 to 5.
Yeah.
So this is not a case where asylum was refused but other status granted. This is a case where asylum was refused, appeal dismissed, and the CI and CI's mother remained for some years as overstayers, and then eventually succeeded by reference to a later policy, and succeeded by reference to the fact that they had remained in the UK for that period of time, because but for remaining unlawfully in the UK, they would not have been able to come within the policy. And whilst I'm on that sort of theme, because the submissions for the Secretary of State and the reasoning of the upper tribunal is that if you do something wrong, you ought not to benefit from it. If one
Well,
goes...
the policy expressly recognises it, I mean, because we're just construing lawfully.
My Lord, yes.
Yeah.
But in the context of the overall operation of immigration control,
Yeah.
so that whether we need to construe lawfully in any other way than what it technically means, if one looks at the long residence policy at page 168 of the supplementary bundle of authorities.
This is the new long residence policy, is it?
No, this is the policy that was enforced in 2017. So this was enforced at the time that SC Jamaica
Yeah.
was decided, because SC Jamaica is the case that applies 276A by analogy to 299, or 399, I think it is, of the rules. But what my lords and my lady will see is that in the example, you have a person that arrives in the UK, refused leave to enter at the port, granted temporary admission, and remains on temporary admission for over 8 years, about 8.5 years. They are then granted 4 years leave to enter after 8.5 years. In my submission, it is not difficult to envisage that most such cases coming within this specific example would likely be granted leave on the basis of circumstances arising during the 8.5-year period. For example, the birth of a child, the establishment of a relationship. Very unlikely that after 8.5 years, you're granted leave because you had an entitlement when you arrived. But when calculating lawful residence, that entire period is counted, and therefore immigration policy doesn't simply look at your conduct and decide that because you've conducted yourself in a way that falls short of what is to be expected, you are going to be penalised for that. In fact, policy, in a sense, positively rewards it in this example. If I then go back to CI, in the main authorities bundle, at paragraph 77, which is at page 176. My submission, it is not right that section 117C4, exception 1, does not permit a decision maker to take account of deception when applying exception 1, because one can see from paragraph 77 that in saying what the judge should have done, and the Court of Appeal states that the judge should simply have asked whether, having regard to upbringing, education, employment history, history of criminal offending, and of course deception, it has been established, amounts to criminal offence, and any other relevant factors. And in my submission, when assessing whether a person is socially and culturally integrated, it is perfectly legitimate for a judge to take account of the fact that there has been criminal offending in the past in the form of using deception, and of taking that into account as any other factor. And that, in my submission, underscores the submission made by the appellant, that the statutory scheme already takes account of deception and caters for it. There is no reason to read something into other provisions to reach a purposive construction when there is no reason to, because the scheme already caters for it in multiple different ways and in numerous different locations within the scheme, both the rules and the statutory framework. If we go to jeunesse at page 98 of the same bundle,
Yeah.
paragraphs 102 to 104, the European Court of Human Rights discusses the distinction between somebody whose presence is tolerated and somebody who is lawfully resident. And one can see it, 102, second sentence, her stay in the Netherlands therefore cannot be equated with the lawful stay where the authorities have granted an alien permission to settle in their country. And at 103, the tolerating of presence is allowing somebody to await a decision on an application for a residence permit. And at 104, the first sentence again, settled migrants being considered persons who have already been granted formally a right of residence. And then a subsequent withdrawal of that right obviously needs to be assessed by reference to Article 8 considerations. And I referred to the consequences that were set out in the decision letter of now being in the UK unlawfully.
Yeah.
The quality of residence when you have a right granted by a state is very different to the quality of residence where you have no such right. And that is what the Article 8 assessment is all about. That is what exception 1 is about. It is not, in my submission, surprising that an approach is taken that is very clean, very consistent to considering lawful presence. If there is any wrongdoing during that lawful presence, that will be taken into account at the second stage when one is considering social and cultural integration. One doesn't need to read the section in a way that is unnatural in my submission. And if one then goes to Akinyemi at page 149 of the bundle, same bundle,
yeah,
at paragraph 37, reference is made to the submissions of Mr. Drabble, King's Counsel, and an extract from Chief Adjudicating Officer and Walk, and Lord Hoffman's judgment there. The key concept in UK immigration control is that of having leave to enter the United Kingdom. And further on, in the second paragraph, reference to the scheme relying upon the exercise of control at the frontier, differentiating it from the system of control in Europe, and concluding with the sentence, his right to enter is a consequence of his having that right to be there rather than the other way round, meaning in my submission that you have a right when you've been granted the right. The sort of language of legitimate expectation is relevant when one is assessing proportionality and when one is exercising discretion. It is not relevant to the system operated domestically, which is constitutive, which means you have a right when you've been granted it. If you haven't been granted it, you don't have a right, regardless of whether you qualify for it, and the other way around. The system is very different under EU law, but this is the system that is operated domestically. And further at Akinyemi, at paragraph 38, Counsel for the Secretary of State, at paragraphs 38 and 39, asked the court to interpret the statutory provision by reference to jeunesse and European Court authority and the underlying purpose of the provision. But at paragraph 40, the court preferred the submissions advanced by the appellant. The question was what this provision was referring to, and the construction was arrived at for two reasons. Paragraph 41, first, ordinary use of language, and in my submission, the ordinary use of language in section 117C4A in the context of the overall scheme, the statute, is if you have leave, you're here lawfully. And secondly, a construction which focuses on removability rather than a positive right to remain. Of course, in the appellant's case, for ground one, he's saying it's not just that I wasn't removable, I actually had a positive right to remain under law. And for ground two, he's saying I wasn't removable at the time because I'd applied. I'd been granted temporary admission. I wasn't removable until a decision had been made. And when the decision was made to grant me leave. And that is exactly how 276A works.
And what do you say to sort of Mr. Tabori's point, which was to 41, to the effect that there is a specific breach, a legal obligation which was breached, which was entry in by using deception.
My lord, if one looks at the facts of this case, and I think the facts are set out in the upper tribunal's decision at paragraph 2, which is at page 21.
Yeah.
And I think it's also set out in the decision to revoke indefinite leave to remain. When one says that he entered the UK on the 4th of October, that might be correct in terms of what he did, but it's not correct in terms of the legal effect of what he did. He arrived in the UK. Entry is if you go past border control and you're granted leave to enter, or you illegally enter. What he did was he arrived and he immediately on the same day claimed asylum. And pursuant to that claim for asylum, he was granted temporary admission. So there isn't any illegality there. Had he entered clandestinely, gone into the UK beyond border control, and then turned up a few days later, a few weeks later, he would have been an illegal entrant. But if you present yourself upon arrival and claim asylum, that isn't illegal entry.
Even though you've arrived clandestinely.
My lady, yes, because you haven't entered. So if you arrive with an entry clearance that has been obtained by deception, but you present yourself at the border and you claim asylum, you haven't yet entered. And I think, say, Schedule 2 of the 71 Act also proceeds on the same basis, so that you're not deemed to have entered if you're granted temporary admission until and unless you are granted leave. And if you do go beyond, that is entry. And so in my submission, the facts of this case are clearly very far removed from the facts in CI. Notwithstanding the deception, he did arrive and claim asylum immediately and was granted temporary admission. And upon the consideration of his claim, he was immediately granted leave. Akinyemi, SC and CI do not consider the question that needs to be answered by ground 1 of the appellant's appeal. That simply hasn't arisen for decision in any of the cases. It does assist with ground 2, and the appellant submits that SC is clearly the leading authority on it. CI considered it to be binding, and when one applies SC, the outcome clearly is you apply to 276A by analogy, and on the facts of the appellant's case, that period ought to be treated as lawful residence. If I could then just very quickly go to the decision of Judge Mandalia.
Yeah. Which is supplementary authority, isn't it?
My lord, yes, at page 136.
I'm conscious that it's turned 1. I'm very happy to give you extra time if it's only going to be five minutes.
I think, my lord, it's going to be in about 5 minutes. I'm pretty much at the end of it.
Okay. And let me just check. Is that all right with everyone down here? Okay, fine. Yeah. Otherwise, we'll break.
Yes. If you think that I am going to stray longer, and
I don't know how long you make.
I don't expect it to be very long.
Reply, but a reply. Of course, you must deal with this authority.
Yes. So, my lords, at paragraph 21, Mr. Biggs himself, appearing for the Secretary of State before Judge Mandalia, acknowledged that one has to interpret the rule in that case otherwise than in accordance with its ordinary meaning. He says there has to be a sensible, purposive interpretation, and that the rules themselves don't suggest that one construes leave obtained by deception as unlawful leave. His submission was that the 71 Act makes it clear that a person is in the UK unlawfully if they are in the UK in breach of immigration laws as defined by Section 33 of the 71 Act. That isn't developed, and in my submission there is nothing in the 71 Act. We've seen Section 33 earlier this morning that suggests that somebody that breaches immigration laws is thereby here unlawfully when they're being granted leave to remain.
Well, except the last bit of the last sentence of that paragraph, it's apparent, he submits, therefore unlawful in the UK if they reside in the UK with leave obtained by deception.
My lady, my submission would be that that is, I'm not sure how it is apparent. It might be apparent instinctively, but one has to make reference to the provisions that make that apparent, and there's no reference to those provisions because in my submission there are no provisions that make it apparent.
You're sort of repeating the point you made already.
Yes.
All right.
And then you see it, paragraphs 24 and 25, that what Judge Mandalia is doing here is interpreting the rules by reference to the principles of interpreting the rules, and those are of course different to the principles that are applied in interpreting section 117C 4A, which is strict.
There's no relatively recent authority that suggests that, broadly speaking, the same principles of statutory interpretation apply to the rules as well as to...
Judge Mandalia's own decision says that it's not as strict and that there's a wider...
Well, it may do, but I mean, I just have a feeling that there's more recent authority there. Anyway, be that as it may be.
At 25, it is acknowledged that the rules themselves provide an exhaustive definition of the meaning of lawful residence for the purpose of the rules. Paragraph 27, the submission was that residence with leave to remain that has been obtained by deception is unlawful because section 24A creates a criminal offence, and I go back to my submissions this morning that the 71 Act creates other criminal offences, and one cannot say simply because a person, for example, has worked in breach of conditions that renders their residence unlawful, particularly where the statutory scheme requires that leave to be cancelled, and that is again discretionary cancellation. And again at paragraph 31, the reasoning that leads Judge Mandalia to the conclusion that he reaches relies on the fact that there is a criminal offence committed when you use deception, and relies on a purposive interpretation of the rule. And my submission is, my lord, first of all, that this is not interpreting the rules, this is interpreting a statutory provision. There is no reason to interpret it purposively because the meaning is clear and it sits very comfortably and coherently and consistently within the overall statutory scheme. And in my submission, when one looks at the exhaustive definition of lawful residence in the long residence rules, when one looks at the various criminal offences created by the 71 Act, then arguably this decision ought not to be followed in any event in construing section 117C4A. My lords, my lady, unless there is anything further that I can assist you with, those are my submissions.
No, well, thank you very much.
Well, I've just been told something in relation to the cautions, and I wonder if we might look into this a little bit more to see if it might assist you, because it seems as though there is reference to 2 prior sanctions of false representation in 2012 recorded as caution. So it might well be that the 2013 caution was in fact for some false representation, and it might be that the passage from the FTT's determination.
Well, I tell you what, if that's you finished orally,
yeah.
We're going to reserve our judgment. That won't be a great surprise at 1:05. And what we'll do is direct that you are to liaise with each other and put in an agreed factual note of the situation. If you can't agree, then obviously put in your respective notes, and we will then see whether anything arises from it. But I doubt it's critical, but it's just better for us to know exactly what went on. Well, thank you very much indeed for the very helpful submissions on both sides. We will reserve our judgment, which will then be distributed to you with the embargo. Please respect the embargo, because it's always very disappointing to get into issues of criminal contempt and civil contempt if they're not adhered to. And we'll try and produce that as soon as we can, but obviously there are other matters to deal with as well.
I'm very grateful.
Good. Thank you very much.
All rise.